Speaking on
lost
this
audio.
issue, very pleased to introduce the gentleman who will speak to us. He is Dr. John Eastman, who's a board member of
David, I'm no
Claremont.
longer hearing you. I can see you talk.
Okay, so I'm going to do a quick introduction and then John is going to take it over. So the next session is weaponization of the 14th Amendment. Speaking on this issue, John Eastman. Dr. John Eastman is a board member at the Claremont Institute. Dr. John Eastman represented President Donald Trump in several matters, challenging the illegality in the conduct of the 2020 elections. He has provided expert testimony to numerous committees in Congress and in state legislatures. He has appeared on numerous television and radio programs and networks. So, John, we'll turn it over to you.
Okay, David, why don't you call me back on my phone so that I can hear the other end if we get questions or anything. I wasn't sure about the introduction, but I'm John Eastman, former professor of constitutional law and dean at Chapman University School of Law, and currently a senior fellow at the Claremont Institute, where a quarter century ago I founded its public interest law firm, the Center for Constitutional Jurisprudence. Among my scholarly work is included an in-depth assessment of the language of the 14th Amendment, including particularly the Citizenship Clause. And most people really don't understand what the clause applies or understand what the dispute is about. So I want to make clear on the front end, this is not a birther revisited issue. Was Kamala Harris or Nikki Haley or any of the people that are part of this debate because of their status when they were born, or more precisely their parent status, has nothing to do with whether they were born on U.S. soil. The dispute is whether they were born subject to the jurisdiction. And that phrase is ambiguous. And we should acknowledge that ambiguity and trying to explore what the people that drafted it meant. The 14th Amendment Citizenship Clause provides that all persons born, that's on the U.S. soil part, or naturalized in the United States and subject to the jurisdiction thereof are citizens of the United States and of the state wherein they reside. I emphasize that word "and" in the middle because it's critically important. There are two elements required for constitutional citizenship or 14th Amendment citizenship, birthright citizenship, if you will. You got to be born on United States soil and you have to be subject to the jurisdiction thereof. Now, modernly, that phrase subject to the jurisdiction is often equated with just subject to the laws. And unless you're the child of a diplomat, anybody born in U.S. soil, anybody within the borders of the United States are subject to the laws of the United States, and therefore, so the argument on the other side goes, subject to the jurisdiction, and therefore the children are automatically citizens. That's not what the founders or the drafters of that language had in mind. And we know this because they were asked directly that question. You got to put yourself back into their mindset at the time. And they had two different understandings of that phrase. Subject to the jurisdiction, did it mean partial or territorial jurisdiction, or did it mean complete and allegiance-owing jurisdiction? Partial or territorial jurisdiction is equated with subject to our laws. And if you're within our borders, you got to comply with the law. The analogy I often draw is if you're in the United States, when you're driving here, you have to drive on the right side of the road, not the left side of the road. That means you're subject to our laws here. But you're not subject to that greater jurisdiction, that complete jurisdiction. You owe no allegiance to the United States by being here as a mere visitor, as a temporary sojourner, to use the language that was in common discussion in the debates over the 14th Amendment. People temporarily passing through or visiting, or here on a temporary student visa or a work visa. They were all considered temporary sojourners and not subject to the complete jurisdiction of the United States in the sense that they owed allegiance to it, but clearly subject to the partial or territorial jurisdiction of the United States. And it's that confusion and essentially that folks that say anybody born here, no matter the circumstances, are automatically citizens. that they overlook. They essentially take a red pen to that phrase and subject to the jurisdiction and write it out of the Constitution. And as I mentioned a moment ago, we don't have to speculate about which meaning of that phrase subject to the jurisdiction they intended, because they were asked point blank what they had. Now, not in the context of immigrants to the country, but in the context of Native Americans. Will they be automatically citizens? The primary sponsor of the bill in the Senate and the drafter of the language in the Senate both responded that no, they would not be, because they owe their allegiance to a different sovereign, their tribes, and therefore they are not subject to the complete jurisdiction of the United States, and this clause will therefore not mandate that they have citizenship. That's critically important, as is the language of the 1866 Civil Rights Act, that this provision was intended to constitutionalize. That language made it a little bit more clear. All persons born in the United States and not subject to any foreign power are citizens of the United States. The reason that language was changed is not to create a broader grant of citizenship, as some people have claimed, but because it did not extend to Native Americans who were not foreign powers, but domestic powers. And so they got rid of the language in the Civil Rights Act that had created some confusion about that, and just said all persons born in the United States and subject to the jurisdiction are citizens. So we have to look at what that citizenship means. Now, the first time, the leading treatise writer of the day wrote that it means subject to the jurisdiction, not owing allegiance to anyone else. The first time that the United States Supreme Court confronted the issue was in a case called Slaughterhouse in 1872, 1873. I'm sorry, I'm just drawing a blank on the exact date at the moment. And there the court was very clear. Now, this is dicta. It was not part of the holding of the case, but the court was very clear. It said, I'm trying to pull it up on my screen so I get the exact language for you. That clause was intended to mean to exclude from its operation ministers and consuls, those are the diplomats, and everybody agrees that it excluded that. But then the court goes on and says, and citizens or subjects of foreign states born within the United States. The foreign states, to parents who were citizens or subjects of foreign states, who were here as temporary visitors, who had not achieved status as a citizen or even status as a lawfully and permanently domiciled resident of the United States, but retained their allegiance to their foreign power. And why is this so important? Because the founders did not, and this rolls into the debate over natural-born citizen. You had to be a citizen from birth, never owing allegiance to a foreign nation, because the founders of the natural-born citizenship clause in the main body of the Constitution were particularly concerned about foreign efforts to influence our politics and to pick somebody to hold the highest office in the land and to be the commander-in-chief of our armies who had a foreign allegiance. So the citizenship clause and that language subject to the jurisdiction thereof tracks the original meaning and the import of the natural-born citizen clause. We didn't want foreign influence infecting our politics, particularly in the highest office of the land. And you know, you look at the language and you understand it in those lights, and you look at the debates, and you look at the specific questions that are asked of the drafters. Here's what Jacob Howard, he introduced the language on the floor. He was asked directly, you know, would this apply to Native Americans who owe allegiance to their tribes? And he said, no. He said the phrase should be construed to mean a full and complete jurisdiction, the same jurisdiction in extent and quality as applies to every citizen of the United States now. That is under the 1866 Civil Rights Act when he said that. And that means not subject to any foreign power. Senator Lyman Trumbull, who was the key supporter of the 14th Amendment in the Senate, When he was asked the same question, he responded, subject to the jurisdiction meant subject to its, quote, complete jurisdiction, quote, not owing allegiance to anybody else. And that's, I think, the key to understanding that subject to the jurisdiction clause. That's in the debates in 1866 to the 68. It's in the Supreme Court, first time they even confronted the language in the slaughterhouse cases of 1873. And it's in the leading treatise writer of the day, Thomas Cooley, who says exactly the same thing. What was dicta in the slaughterhouse cases became a holding in the Supreme Court's decision in the 1880s called Elk versus Wilkins. And this dealt with a gentleman who was born on an Indian reservation, but within the United States, and he moved to non-reservation territory, renounced his tribal allegiance, and claimed that he was a citizen by virtue of the Citizenship Clause because he had been born within the United States, albeit on an Indian reservation. And the Supreme Court held, no, I'm sorry, you're not, because you owed allegiance at your birth to the Indian tribe, which was a separate sovereign, and not to the United States. You did not meet the subject to the jurisdiction clause requirement as that clause was understood at the time. Now, fast forward in another 15 years, and we have a gentleman born of Chinese parents here. This is he's born here before the Chinese Exclusion Acts. But when he comes of age, he goes back to visit his grandparents in China. And when he returns, the Chinese Exclusion Acts have been passed and he's not allowed to return. And he lays claim to say, I'm a citizen because I was born here. And the Supreme Court agreed that he was a citizen. But in the case, it's Wong Kim Ark is the case. The court goes out of its way, I think 28 different times, to point out that his parents were lawfully and permanently domiciled in this country at the time of his birth. They had done everything they could to renounce their allegiance to the Chinese emperor, even though we would not allow them to become citizens themselves. And the Supreme Court said, because they were domiciled here, that means lawfully and permanently residing here, they were able to convey that subject to the jurisdiction, that element of allegiance owing, that meant their son was a citizen at birth. Now, that court decision has often been misconstrued as establishing that anybody born here on U.S. soil is automatically a citizen, no matter the circumstances of their parents, no matter whether they're here temporarily or permanently, no matter whether they're here legally or illegally, no matter whether they came legally and then overstayed the visa and were hence illegally here at the time of the birth. Everybody that takes this misunderstanding of the Wong Kim Ark say, Supreme Court already settled this. It settled nothing of the sort. And honest scholars for the last century and a quarter have acknowledged that Wong Kim Ark dealt with parents who were permanently and lawfully domiciled in the United States. And therefore, any discussion in the case that goes beyond that is dicta, because the issue of, say, status of somebody born here to illegal immigrants was not presented to the court. And there's a couple of other things here. If the court's decision in Wong Kim Ark had settled the question that subject to the jurisdiction means just subject to the partial or territorial jurisdiction, equating it with subject to the laws, then we see Congress did in the 20s tribes in the treaty. If Wong Kim Ark stood for the proposition that anybody born on U.S. soil was a citizen, that act is to make this offer of citizenship, because in fact they recognize Wong Kim Ark did not make citizens of everybody born on U.S. soil, because what the issue in the case is only the children of lawfully permanently domiciled parents. Fast forward again a little bit. You know, we've had large guest worker programs in the 1920s and 1950s. At the end of the 1920s guest worker program, after the Great Depression hit, millions of people were deported, some quite forcibly and some quite ignominiously not a particularly good in our humanity in this country. But to my knowledge, nobody at the time raised the question that the children who had been born here, who were likewise being deported, were citizens and therefore couldn't be deported. Nobody raised the issue because it was not understood that that issue had been settled. Now, I think pro-1950s, some folks have asserted to me that there was some claims of citizenship made at the time. I've not been able to locate them. What I have located is that many years after the fact, people came back and said, we are actually citizens, you have to let us back in. And by then, the understanding of the import of Wong Kim Ark had started to change. I think it changed in the middle of 1960s. And I'll maybe a little bit earlier, maybe in the 1930s, and I'll go back on that in a minute. But in the 1960s, there was a major revision to the immigration laws in this country in 1965. And that changed a whole lot of things, including requirements for passport eligibility, for which you have to be a citizen. And the form that for passport eligibility used to say if you were born on U.S. soil, you had to describe the status of your parent at birth in order to apply for the passport. Why would that be necessary if you were merely being born here meant that you were a citizen? It was necessary because up at that point, the passport office understood that subject to the jurisdiction meant subject to the complete jurisdiction. And if your parents were here merely as temporary visitors, that did not confer automatic citizenship. The form changed in 1967 in the wake of the 1965 immigration amendments. And that language about asking the status of the parents at birth was dropped. Now, I don't know why it was dropped. We don't find anything in the record describing why it was dropped. My speculation is there were some other things that had to be added because of the 65 Immigration Act, and that kicked it over to 2 pages, and some bureaucrat was told to figure out how to get it down to 1 page, and he said, oh, I don't know why that language is there. I pick up the language, the space I need, and we're back down to 1 page. I have no idea whether that's the case, but knowing government bureaucrats the way I do, it's certainly plausible. There's another possibility, though, there was a report done by the Department of Justice in the 1930s during the Franklin Roosevelt administration that seems to have misunderstood Wong Kim Ark as settling the question that anybody born on U.S. soil, no matter the circumstances, was in fact a citizen. And that report was before the United States Congress when they passed the immigration amendments of 1938. And if that was Congress's understanding of the language of the 14th Amendment when they passed the immigration amendments of 1938, using the identical language as is contained in the 14th Amendment, some, including former the statutory provisions using that same language actually mean automatic citizenship for anybody born here, because that was how Congress understood those words. Now, if that's true, a mere act of Congress can go back to the original meaning of the Constitution by just reading what the original meaning was. Whether we should take that as the dispositive determination of when our understanding of the 14th Amendment changed, because Congress quite deliberately used the exact same language of the 14th Amendment, which meant they intended to offer citizenship to the extent that the Constitution required it, but there's no indication that they intended to offer it more broadly than that. Okay, so how does that play out modernly? Well, it would suggest that those who are born here to parents who are not lawfully present in the United States are not automatic citizens under the 14th Amendment, because the parents retain their allegiance to whichever origin they have come here illegally from, whether Mexico or Russia or China or wherever, or France or Great Britain or wherever. If they're here illegally, they retain that allegiance with maybe one exception, those that are refugees and are no longer having any allegiance to their home country. They may not have any allegiance to a foreign power. Sometime late 1990s, early 2000s, there was a bill to extend birthright citizenship to the children of refugees who would otherwise be stateless. And I supported that bill, but also because it clarified that the constitutional floor meant that you had to be subject to this full jurisdiction. And then how far above that floor we go is the exercise of Congress's power over naturalization, which is perfectly appropriate. The second thing it might mean is that children who are born here of folks who came here legally on a temporary visa. And this issue first came to my attention in one of the terrorism cases, the post 9/11 terrorism cases, the Yasser Issam Hamdi case. Hamdi was captured on the battlefields of Afghanistan and transferred to Guantanamo Bay, like many others were. But when it was learned that he had been born in Baton Rouge, Louisiana, while his father was working on a temporary work visa on one of the oil rigs off the Gulf Coast of Louisiana, they started treating him as a citizen, and they transferred him up to the military brig in Norfolk, Virginia, if I recall correctly, and his case went all the way to the court. We urged the Supreme Court to take up the question whether he was actually a citizen or not. The court declined because it was only raised by us as an amicus, and by us I mean me and former Attorney General Edwin Meese raised this issue in this brief. Justice Scalia, in dissent from that case, refers to Hamdi as a presumed citizen rather than simply a citizen. I like to think that that meant he had read our brief and understood that there was an issue there that he did not want to foreclose further discussion on. But in any event, Hamdi's parents were here temporarily. They were here lawfully. And yet, in our view, he was not a citizen as a result because they continued to owe their allegiance to their home country, both mother and father, which was Saudi Arabia. Even more clear, it seems to me, is if somebody came here legally and then overstayed the visa so that they are now here illegally. And this now all apply to Kamala Harris herself, because after the article I wrote in Newsweek back in August of 2016, raising questions about her citizenship status as a result of this understanding of the 14th Amendment, I didn't know at the time what the status of her parents was. But it seemed there was enough information out there that it seemed worth raising questions about. Been informed by a number of people of two things. One, both of her parents were here on temporary student visas. The dad may have also been here with some diplomatic capacity, which would bring her from his lineage under the understanding of the subject to the jurisdiction clause that everybody agrees with, that the children of diplomats do not gain automatic citizenship because they're not even subject to the territorial jurisdiction of the United States. But in other words, in any event, he was also on a student visa, as I understand it. The mother was as well. The conditions of those student visas were that they expired 60 days after the conclusion of the studies. And that meant if you stayed longer than the 60 days, you were now no longer here lawfully pursuant to that student visa, but you had overstayed the visa and you were now here unlawfully. And I've been informed, I've not done the research on this myself, but I've been informed by several people that have looked into it, that in fact, Kamala Harris's mother finished her doctoral studies in January of 1963. Do I have the year right? Maybe 64. The January of the year that Kamala was born, the following October, which is long past the 60 days allowed after the conclusion of the studies. If that's true, that means that Kamala's mother had overstayed the visa and that she was now here unlawfully. In other words, than folks that had entered unlawfully in their place. And if my understanding of the subject of the jurisdiction clause is correct, that does not apply even to lawful temporary visitors, temporary sojourners, then it clearly doesn't apply to those who are unlawfully temporary sojourners or visitors to the United States. Some have argued it has to be only the children of citizens. I think Wong Kim Ark, whether it's rightly or wrongly decided on this precise question, says otherwise, that if you're permanently domiciled here, you are subject to the jurisdiction sufficiently automatic citizenship on your children. But it doesn't go beyond that. I think that's the critical thing. This is a serious and open question of constitutional law, and it seems to me that it warrants our consideration in a serious way, not tied up with the vitriolic Twitter mob attacks that come when anybody raises the issue. Because at bottom, what's at stake is whether we're going to continue to recognize the difference between citizen and non-citizen. And what's at stake, particularly in the context of the natural born citizenship required for the office of the presidency, is whether we're going to continue to recognize the distinction between those who owe their sole and exclusive allegiance to the United States, or those who, through mixed allegiance, may owe allegiance to a foreign power who may itself at some point be an enemy foreign power of the United States, and then taking the helm of the highest office and the most powerful office in the land, whose duties include not just our foreign policy, but the control of our military. These are questions that citizens ought to be asking, and they're serious questions of constitutional law. And shame on anybody who would just simply go to ad hominem attacks against anybody that even dares to raise these questions. Now, the question is, how do you get it addressed by the courts? Ordinary citizens don't have standing. Some Secretary of State someplace were to deny access to the ballot for somebody on the ground that citizens, because of this understanding of the 14th Amendment, that would create for the candidate who was barred from the ballot. It being more of a suit than we would like to see. Candidates in opposition, I think, would have standing as well if anybody was willing to take it up. But again, this is an open question of constitutional law. Any serious constitutional scholar should be more than willing to recognize that. But the politics of the day have almost made that kind of concession impossible, depending on which side of the political aisle you fall on.
All right, John, hope you can hear me. Thank you very much for speaking to us. It was an excellent presentation, very interesting. Can you hear me, John?
I'm not hearing anything, so if somebody's there, let me know.
Yeah.
John, maybe you can say a few words about Democrats scheming to invoke Section 3 of the 14th Amendment to prevent a duly elected Donald Trump from taking office, and then that'll be off.
I'm sorry. Say one more time.
The risk that Democrats are scheming to invoke Section 3 of the 14th Amendment to prevent a duly elected Donald Trump from taking office.
Okay, will do. So the other issue, and I'm sorry I'm not able to hear on the response side. I'm glad you're still able to hear me, though. Maybe somebody raise their hand or give me a thumbs up to make sure you can still hear me. But the other issue that they want me to address, I'm sorry, it looks like it froze. Maybe David, if you can call me, let me know if you can still hear me. I look
Yeah.
like I'm frozen on my end. Can somebody raise?
Yeah, we can still hear her, so maybe just take like 3 minutes and answer that question.
Sure. Okay. Sorry for the technical difficulty here, folks. So the other question is shifting gears to a vision of the 14th Amendment, Section 3. This is the one that disqualifies Confederate soldiers and particularly Confederate leaders after the Civil War from holding office unless Congress basically gave them a reprieve. This was revived to claim that what occurred on January 6th was the equivalent of the Civil War, an insurrection, and therefore that anybody that spoke in favor of election challenges and therefore was somehow caught up in this grand insurrection conspiracy is ineligible for office for federal government or state government. They tried to do that by excluding President Trump from the ballot in Colorado, and the U.S. Supreme Court unanimously ruled against him at Colorado and said you can't do that. But it did say how this clause gets interpreted is first and foremost a question for Congress. And if Congress wants to treat January 6th as an insurrection and describe it as such, then people that were involved in it would not be eligible for office. I think that opens a door for mischief in Congress that the court should not have opened. But the door was the notion that that was an insurrection within the meaning of the 14th Amendment is, I think, utter nonsense. More importantly, though, in the early 1870s, Congress made the provision for all but few of the top Confederate generals and political leaders. And then that was further waived in the 1890s posthumously, even for them. And I believe language of Section 3, the language is currently operative. So it would take both then the court saying, yeah, inevitably after the fact. And I don't think the court's going to go, I don't think Congress is going to ever get the votes to do that in the first place. And I don't think the courts will accept a retroactive application of it in the current circumstances. But I've, been wrong with the Machiavellian mischievousness of the Democrat Party for a while now. So maybe they would try such a thing as well if they get super majorities enough in Congress to be able to pull it off.
Okay, I think that will end this session. Thank you very much, John Eastman. Excellent presentation.
Okay,
really
again, I'm not able to hear anybody on the other end or even see anybody now. So.
Okay, so anyway, that was a great presentation. Let me just take about 30 seconds to check in with our next speaker, make sure he's ready to go. And then I will do a quick introduction and turn it over to our next speaker.